Good day, sir. We will be discussing sections 45 to 50 of Rule 130 on the rules of court. Starting off with section 45. So section 45 talks about commercial lists and the like. Evidence of statements of matters of interest to persons engaged in an occupation contained in a list, register, periodical, or other published compilation is admissible as tending to prove the truth of any relevant matter so stated if that compilation is published for use by persons engaged in that occupation and is generally used and relied upon by them therein. So, when is a document considered a commercial list? Or kailan natin masasabi na ang dokumentong ito ay isang commercial list? Under Section 45 of the aforesaid rule, a document is a commercial list if, letter A, the commercial list is a statement of matters of interest to persons engaged in that occupation or in an occupation. Letter B, such statement is contained in a list, register, periodical, or other published compilation. Letter C, said compilation is published for the use of persons engaged in that occupation. And lastly, letter D, it is generally used and relied upon by persons in the same occupation. So an example of a commercial list is a NEDA report, or it is a part of the newspaper which reports the prices of shares. So, ganun siya. Okay, that's all for section 45. Let's now move on to section 46 of the Rule 130. Section 46 talks about learned treatises. A published treatise, periodical, or pamphlet on a subject of history, law, science, or art is admissible as tending to prove the truth of a matter stated therein if the court takes judicial notice or a witness expert in the subject testifies that the writer of the statement in the treatise, periodical, or pamphlet is recognized in his profession or calling as expert in the subject. So, what does learned treatise or treatises mean? In the law of evidence, it is a text that is sufficiently authoritative in its field to be admissible as evidence in a court in support of the contentions made therein. Or in legal definition, it is a legal rule establishing a published text as authoritative either by expert testimony or by judicial notice, and is thus admissible as an exception to the hearsay rule. And this may also be used to examine or cross-examine an expert witness. So that will be it for section 45 and section 46. The following sections will be reported by my group mates. Thank you.
Good day everyone. Today I will be discussing the section 47 and section 48 of Rule 130 under the Rules of Court. Section 47, the testimony or deposition at a formal proceeding, says that the testimony or deposition of a witness deceased or unable to testify given in a former case or proceeding, judicial or administrative involving the same parties and subject matter, may be given in evidence against the adverse party who had the opportunity to cross-examine him. This section deals with the admissibility of the testimony or deposition at a former proceeding. It allows for the use of the testimony or the deposition of a witness who is no longer available to testify due to death or inability, provided that the prior testimony was given in a case involving the same parties and subject matter. The testimony can be presented as evidence against the opposing party, granting them the opportunity to cross-examine the witness when the testimony was originally given. This allows for the inclusion of crucial testimony from previous proceedings when the original witness is no longer available. Next is the section 48 under the opinion rule. This section, as a general rule, says that the opinion of a witness is not admissible except as indicated in the following section. Those are section 49 and section 50. This section establishes the general principles that witness opinions are usually not admissible as evidence in any legal proceedings. It emphasizes the importance of factual testimony over personal opinions. The exceptions to this rule are outlined in other sections, defining specific situations where witness opinions might be allowed as evidence in court under any particular conditions.
So now I will be discussing the Rule 130, Section 49 of the Revised Rules on Evidence. Section 49 is opinion of expert witness. The opinion of a witness on a matter requiring special knowledge, skill, experience, or training which he is shown to possess may be received in evidence. Testimonies of expert witnesses are not absolutely binding on courts. However, courts exercise a wide latitude of discretion in giving weight to expert testimonies, taking into consideration the factual circumstances of the case. Although courts are not ordinarily bound by expert testimonies, they may place whatever weight they choose upon such testimonies in accordance with the facts of the case. The relative weight and sufficiency of expert testimony is peculiarly within the province of the trial court to decide, considering the ability and character of the witness, his actions upon the witness stand, the weight and process of the reasoning by which he has supported his opinion, his possible bias in favor of the side for whom he testifies. So the fact that he is paid witness, the relative opportunities for study or observation of the matters about which he testifies, and any other matters which serve to illuminate his statements. The opinion of the expert may not be arbitrarily rejected. It is to be considered by the court in view of all the facts and circumstances in the case and when common knowledge utterly fails. The expert opinion may be given controlling effect. The problem of the credibility of the expert witness and the evaluation of his testimony is left to the discretion of the trial court, whose ruling thereupon is not reviewable in the absence of an abuse of that discretion. So let's go now to the Rule 130, Section 50, which is the opinion of ordinary witnesses. The opinion of witnesses, which is proper basis is given, may be received in evidence regarding A. The identity of a person about whom he has adequate knowledge. B is the handwriting with which he has sufficient familiarity. And C, the mental sanity of a person with whom he is sufficiently acquainted. The witness may also testify on his impression of the emotion, behavior, condition, of appearance of a person.